Imagine for a moment that you were at a party on a Friday night. The music is loud, the energy is high, and you are having the time of your life. Naturally, you pull out your phone. You snap a quick photo of your friend holding a drink. Maybe there's a little bit of something else on the table in the background. You do not really notice it. You post it to your close friend's story on Instagram. You think to yourself, it's fine. It disappears in 24 hours, and only my real friends can see it anyway. But what if I told you that 3 weeks later, that exact photo is printed out, sitting in a manila folder on a detective's desk, marked Exhibit A? What if I told you that the privacy settings you rely on are, legally speaking, almost completely imaginary? My name is Sarah. For over 15 years, I've watched people lose their freedom, not because they were guilty, but because they didn't understand how the law really works. Today, we are not just talking about privacy settings. We're diving deep into a terrifying reality that most people simply ignore until the handcuffs are already clicking shut. We're going to answer the question, can police use your social media against you? The short answer is yes. The long answer involves a legal minefield of fake profiles, secret informants, and a Supreme Court doctrine that might just keep you up at night. Let's get into it. To understand how this works in the real world, let me walk you through what happened to a young man named Liam. Liam is a regular guy. He has a job, he pays his bills, and like millions of other people, he lives a significant part of his life online. Liam is smart, or at least he thinks he is. He has his Facebook set to private, his Instagram is locked. He does not add people he doesn't know. Well, mostly. One weekend, Liam buys a new car. It's a used sports car paid for in cash. He's proud of it. He takes a picture of the car in his driveway and posts it with the caption, "Paid in full, hard work pays off." Now, Liam doesn't think this is a crime. It isn't. But what Liam doesn't realize is that the police in his town have been investigating a series of high-value thefts in the area. They have a vague description of a suspect, but nothing solid. However, they do have a specialized unit. This unit doesn't patrol the streets in cruisers, they patrol the digital streets. They patrol Facebook, Instagram, TikTok, and Snapchat. This brings us to our first major legal concept, the plain view doctrine. In the physical world, if a police officer is standing on a public sidewalk and looks through your open living room window and sees illegal contraband on the table, they do not need a warrant to see it. It is in plain view. Courts have overwhelmingly applied this same logic to social media. If your post is public, meaning anyone on the internet can see it, you have zero Fourth Amendment protection over that post. You have voluntarily exposed it to the world. Police officers can screenshot it, print it, and use it to build reasonable suspicion. Reasonable suspicion is a legal standard that is less than proof, but more than just a hunch. It means they have specific facts that would make a reasonable officer suspect that a crime is happening. Back to Liam. His post about the car was private, right? Well, not exactly. Liam had shared it on a secondary platform, maybe X, formerly Twitter, where his account was public by default. He forgot to check. An officer scrolling through local hashtags like #NewWhip or searching for keywords in the area finds the photo. Now, owning a car isn't illegal, but the officer notices something else in the background of the photo. In the reflection of the car door, there is a stack of distinct colored boxes that match the description of stolen goods from a warehouse robbery 2 days prior. Liam didn't even see them, but the digital detective did. This is mistake number one, assuming that private on one app means private everywhere. But let's say Liam was smarter. Let's say he truly locked everything down. Only approved friends could see his posts. He's safe, right? Wrong. This is where we enter the murky, often misunderstood world of undercover social media operations. This brings us to the case of United States versus Gatson. In this case, a court ruled that police officers can legally create fake social media profiles to investigate suspects. They can use a fake name, they can use a fake photo, they can pretend to be a pretty girl, a car enthusiast, or a friend of a friend. Liam gets a friend request on his private Instagram. It's a girl named Chloe. Her profile looks real enough. She has a few hundred followers, photos of food, photos of pets. She follows a few people Liam knows. Liam thinks, maybe I met her at that party last week. He accepts the request. In that split second, Liam just waived his Fourth Amendment rights. By clicking accept, he voluntarily granted Chloe access to his private life. The fact that Chloe is actually a 45-year-old detective sitting in a precinct 3 miles away doesn't matter to the courts. The judge in the Gatson case ruled that this is consensual sharing. You invited them in. A lot of people scream entrapment when they hear this, but entrapment is a very specific legal defense where police force or coerce you into committing a crime you wouldn't have otherwise. Sending you a friend request isn't coercion, it's just a digital knock on the door and you opened it. Once Liam accepts Chloe, she can see everything. She sees the stories he posted about partying, she sees the locations he tags, she sees the comments his friends leave, which might contain incriminating nicknames or details. But the danger isn't just from fake accounts, it comes from real ones too. This is perhaps the most critical concept you need to learn today, the third-party doctrine. The third-party doctrine is a legal principle derived from Supreme Court cases like Smith versus Maryland. It essentially says that if you voluntarily share information with a third party, like a bank, a phone company, or in this case, a friend, you no longer claim a reasonable expectation of privacy in that information. Let's go back to Liam. Liam is cautious. He ignores the request from Chloe. He only has his 20 closest friends on his account. He trusts them with his life. He posts a picture of himself holding something illegal. Let's say it's a weapon he's not supposed to have. He captions it, "They'll never catch me." One of his friends, Sarah, gets arrested for something totally unrelated, maybe a DUI. She's sitting in the interrogation room, scared, looking at potential jail time. The detective says, "Look, Sarah, if you help us out with some information on other people in your circle, maybe we can talk to the district attorney about your situation." Sarah pulls out her phone, she opens Instagram, she shows the detective Liam's photo. Is that legal? Can the police use that? Yes. Absolutely yes. In the case United States versus Marigildo, the court held that when you post something to your social media profile, you are sharing it with your friends. You are assuming the risk that one of those friends might be a government informant or might just turn into a snitch to save their own skin. Once Sarah shows the officer the phone, the officer has seen the evidence legally. Your privacy expectation is gone because you gave the data away. This is what terrifies privacy advocates. You are only as secure as the least trustworthy person on your friends list. So you might be thinking, okay, but what if I don't friend anyone? What if I just use Messenger or direct messages? This is where the heavy artillery comes in, the Stored Communications Act and search warrants. Police don't always need to trick you. If they have probable cause, that is, enough evidence to convince a judge that a crime has been committed and evidence exists on your account, they can simply bypass you entirely. They draft a warrant, they sign it, and they send it directly to Meta or X or Snapchat. These companies have legal departments dedicated to responding to these requests. If the warrant is valid, the company hands over the data. And here's the kicker. They don't just hand over the photos you see on your timeline. They can hand over private messages. They can hand over IP logs that show exactly where you were when you logged in. They can sometimes even retrieve data you thought you deleted. Talk about deletion for a second. Many people believe that hitting delete scrubs the digital footprint. In the world of digital forensics, delete rarely means destroy. It usually just means hide from user view. When you delete a post, it's often flagged on the server as deleted, but remains in the backup archives for a set period of time, sometimes 30 days, sometimes 90, sometimes longer, depending on company policy and preservation orders. If police send a preservation letter to the social media company the moment they start investigating you, that data is frozen. Even if you delete your entire account, that preservation order compels the company to hold on to your data until a warrant arrives. So let's recap Liam's situation. He tried to be private, but he failed because of the plain view doctrine on a forgotten public account. He failed because he accepted a fake friend request, falling for the consensual sharing trap, or he failed because a real friend showed his posts to the police under the third-party doctrine. The result is that the police now have the photo of the stolen goods, they have the IP address placing him at the scene, they have the messages bragging about the money, they have everything they need to get an arrest warrant. And when Liam is sitting in court, his lawyer will have a very hard time suppressing this evidence. Why? Because Liam gave it to them. He didn't mean to, but legally he did. So what can you actually do? Is the answer to just delete everything and live in a cave? No, that is not realistic, but you must operate with what I call digital discipline. Here are the takeaways you need to remember. 1.
Treat every single post, message, and comment as if it is being projected onto a billboard in the middle of Times Square, because if the wrong person sees it, it basically is. 2. Audit your friends list. If you do not know who Chloe or John is in real life, they should not be seeing your personal life. The courts have made it clear, strangers can be police, and police can be strangers. 3. Understand that private is not a legal shield, it is a social setting. It stops your aunt from seeing your party photos, but it does not stop a subpoena, a warrant, or a snitch. 4. Never discuss crimes online. This sounds obvious, but you would be shocked at how many convictions are secured because someone bragged in a DM. And finally, number 5, if you are ever questioned by police about your social media, or if they ask for your phone password, you have the right to remain silent. You have the right to refuse a consent search. You can say, "I do not consent to a search of my device. I want to speak to a lawyer." They might take the phone anyway if they have probable cause, but do not do their job for them by unlocking it and giving them a tour. Make them get a warrant. Social media is a tool. It is fun. It connects us. But in the eyes of the law, it is also a massive self-generated database of evidence. Don't build the case against yourself. Stay smart, stay educated, and protect your rights. If you found this deep dive helpful, make sure to subscribe for more breakdowns on how the law affects your daily life. I'll see you in the next one.